Turn to the third case on this morning's docket, case number 111785, State of Kansas v. Belts. Counsel, as I asked counsel on the prior case, for the benefit of our audience, would you take maybe 60 seconds and give us just a few facts so we know what we're dealing with?
Absolutely.
Thank you.
May it please the court, I'm Ryan Enninger here on behalf of the defendant appellant Kyle Belts. With the court's permission, I'd like to request 3 minutes for rebuttal.
3 minutes is granted.
Thank you, Your Honor. For the benefit of our guests, I can give a short factual recitation in this case. Essentially what happened here is my client, Mr. Belts, was friends with two individuals, Kyle Carricker and Mr. Betts, Ronald Betts. And what happened here was Mr. Carricker was apparently out driving in his car, had stopped at a railroad crossing, and was smoking marijuana. He encountered some other individuals there, Lorenzo Spires, Mr. Haynes, and Mr. Carter. I don't know if Mr. Carter was actually present at that time, but anyway, Mr. Carricker ends up discussing marijuana with these individuals, offers to sell them a quarter pound of marijuana. At that point, Mr. Carricker and Mr. Betts were not associated with each other, is what I understand. The evidence was that my client, Mr. Belts, put Mr. Carricker and Mr. Betts together in order to arrange a marijuana transaction between Mr. Spires, Mr. Haynes, and Mr. Carter. My client, Mr. Belts, stated that he put these individuals together to some extent, but then also told them that he instructed them to conduct the transaction outside of his residence and not to bring these people into his home. What ended up transpiring is my client, Mr. Belts, was in his home. Mr. Carricker arrived, Mr. Betts arrived. My client apparently went to his bedroom, hid him. Well, he gave statements to officers saying that he was in his bedroom when these individuals arrived, Mr. Spires and Mr. Haynes and Mr. Carter. They arrived. Mr. Betts and Mr. Carricker went out to meet them. Apparently, there was Mr. Spires and Mr. Haynes. Their plan was to actually just rob Mr. Belts or Mr. Carricker and whoever showed up with the marijuana was going to be robbed by these three individuals. They had no intention of purchasing it. Apparently, Mr. Betts invites these individuals into Mr. Belts' home to complete the drug transaction. At which point, one of the individuals, I believe it was Mr. Haynes, begins firing his weapon. He shoots Mr. Carricker. Mr. Carricker is my client, Mr. Belts, says that he was in his bedroom when he observed these individuals arrive. They arrive. He retreats to his closet with his shotgun. When the shooting starts, apparently Mr. Betts flees from that area. My client, Mr. Carricker, is in the closet with the door shut. As far as I know, he opens fire and striking someone who turns out to actually be his friend, Mr. Betts. He is charged then and convicted of felony murder for the killing of Mr. Betts, based on the underlying predicate felony of attempted possession of marijuana with intent to distribute. So that's how we ended up here before the court today.
Very well, thank you.
I have 4 issues in the brief this morning. Unless the court directs me otherwise, I'd like to focus my attention on the first and third issues. The first issue involves the district court's, we've claimed it's an erroneous admission of 6455 evidence relating to prior drug sales involving Mr. Betts, my client, also Mr. Belts, that occurred at Mr. Belts' residence, whether they were outside or inside. So the district court allowed in testimony regarding the fact that there's been a number of other prior sales. The second part of the evidence was that when they served a search warrant on the home, they discovered that there was what appeared to be a recently cleaned up or removed marijuana grow operation.
Was there any objection made to the lab evidence?
Yes, Your Honor, and that's the first bit of the first part of what I need to address was the preservation issue. Volume 13, page 113, trial counsel states that he's renewing his pretrial objections. He objected to the evidence. He said, "I'm renewing all my pretrial
Right.
motions at this point."
And did he
Now,
object to the evidence of the grow
I
in the
think-
pretrial motions?
What I think he was doing there was trying to reassert. He said, "I'm reasserting all my pretrial motions."
Okay, let's
which
assume
he-
that that's true.
Right. He'd objected to.
Where
those
in the
before.
pretrial motions was there any 455 objection made to the grow evidence?
The pretrial motion was
My understanding is there was a suppression motion filed.
correct, but there was a motion. There was a hearing based on just the 455.
And did that have? Can you direct me to, or can you just tell me whether or not that included the grow evidence, the evidence of the marijuana in the house?
I want to say
as
that
opposed to and distinct from the evidence of the sales.
I
that were
understand what you're
occurring.
saying. Was his trial objection that I object based on my pretrial motions was sufficient to? Did he have a pretrial motion
Exactly.
that would have renewed? I'll have to double check perhaps when I sit down for rebuttal. But I believe
Okay.
that they discussed those.
If you could check that, that
I
would
will.
be good.
Thank you. The other sort of issue here is there was testimony prior to him saying I'm objecting based on pretrial, my pretrial motions or renewing my pretrial motions. There were statements that came in a page or two before that regarding the grow operation. The argument that I would have to that is that based on the spirit of the rule, which and the purpose of the contemporaneous objection rule, which is to allow the district court, afford the district court an opportunity to revisit a prior ruling to prevent if there's going to be a change in the district court's mind regarding that prior ruling, that there's sufficient time and opportunity afforded for the court to do so.
Even if
That
it later
is-
hurts you on harmlessness, I mean,
I'm sorry.
but even if we get past that and we get to harmlessness, does that fact that other evidence came in,
Right, that
leads
it's
you to a
already,
harmless-
that the cat is out of the bag in some sense at that point. I would argue that basically they gave the court an opportunity to say, well, what the trial court could have done at that point was say, I've changed my mind, and the jury can disregard that limited bit of what did come in. So I think that would have, if the court was going to change its mind regarding those pretrial rulings, I think that would have been a sufficient safeguard.
so we still have another possible error, but that still doesn't answer why is it not harmless?
Well, would you like me just to address harmlessness in general?
About this evidence, how did this evidence,
How does the evidence of prior drug sales as well
the
as
grow lab?
the grow
We're
lab?
talking about the grow
not-
lab right now.
How is that not a harmless error problem? I would argue in the brief, and I think what was argued before is what we have here is we have a claim by my client that, he essentially says, and he says this to the officers during his interviews, and there's plenty of evidence there that says, I'll say that, I set up this put these people together for the arrangement. I made these phone calls. I put these people together. I told them they could do this outside my home. His defense then is that, but I told them they had to do it outside. Once they came in, it's a completely different ballgame at that point.
So you're
so the
saying that
evidence-
if the aiding and abetting has been completed before the crime is completed, then with respect to the aider and abetter, it's not in the commission of that felony?
That would be the argument, that once he's told these individuals to go out to do this outside, they ignore his directive and return to the home. His aiding and abetting liability is ended at that point, and it changes the situation.
What is he aided and abetted?
Well, I think, and the state's entire theory here was that he arranged, it's an attempted possession, that he arranged this drug transaction. His involvement would have been aiding and abetting and even the overt act was alleged in the state's complaint, was to put these two people together and then providing a meeting place for them. And so those would be the two acts that were alleged by the state. As far as the aiding and abetting go, those things were complete at the time those Mr. Betts and Mr. Carricker went outside. As far as general harmlessness, I mean, instead of having the jury focus on just this question that I've just addressed for the court, now the jury's looking at, well, here's a guy who's growing marijuana in his basement. He's involved in all these other prior transactions, so it becomes just a simple, well, this is the kind of person that's involved in this. This is just sort of a bad guy, and you're looking to sort of find one way or another somebody's going to get hurt in this situation. Would be my harmlessness argument. Unless the court has additional questions on the 6455, I think I'd like to take just a minute to address the sort of overarching issue in this entire appeal and what became the biggest issue in his trial, and that's just the question of whether Mr. Belts was entitled to a self-defense instruction under the facts of this case. As I previously addressed, Mr. Belts' almost his entire defense, his defense was really two-pronged. One was I was not involved in the whole, essentially what they were doing what they decided to do outside was I'm done with the transaction. Essentially, after he admitted I put these individuals together. They met within my home, Mr. Betts and Mr. Carricker. After that, I told them they could do this, but they had to do it outside. At that point, Mr. Belt said he was in his closet, or in his bedroom rather. He sees these individuals arrive in the driveway or outside. He goes to his closet with his shotgun. At that point, he sees them come in, is what he said. And the argument that was made was that trial counsel basically said that the real predicate felony here was an aggravated robbery by the three individuals that came in. It wasn't actually the marijuana offense by Mr. Belts. But I think the actual way that it should be reviewed is the question of whether there were sufficient facts for the jury to decide what is the ultimate issue in this case, which was, okay, was this act of discharging this firearm done in the furtherance or the commission of the underlying predicate felony, or was this an act of self-defense after Mr. Belts' involvement in that underlying felony had ceased? He was charged with aiding and abetting by the state on two grounds, arranging the transaction and providing a meeting place for it. That's what the complaint stated. He did not testify, but in speaking with officers, that evidence was admitted. His interviews where he said, I saw these people, I went to my closet because I told them they weren't supposed to, I didn't think they were going to come in. I went to my closet with my shotgun. Almost immediately upon entering the home, these people start shooting. At that point, Mr. Belts argued that restored my right to act in self-defense. That the trial court essentially found that you're precluded from offering or presenting a self-defense argument or an instruction simply because you're involved in the commission of a forcible felony. And what that does is it removes that's really the ultimate question. The jury needs to decide whether or not he was involved in a forcible felony when he discharged that firearm. And that's the argument, I think, that is really the largest argument in this case, is the jury wasn't afforded that opportunity in this instance. The jury wasn't afforded an opportunity to decide, was Mr. Belts still in the commission of attempted possession of marijuana with intent to distribute when he fired his shotgun, or had his aiding and abetting involvement been completed at that time and he was acting in self-defense. Unless the court has any additional questions, I would be willing to submit the remaining issues on the brief and yield to the state.
Any more questions? Thank you, counsel.
Thank you.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I'll also argue issues 1 and 3 here today and submit issues 2 and 4 on the brief. With respect to issue 1, our argument is twofold. First, our position is that the defendant did not properly preserve this for appellate review. Alternatively, we would also argue that if the merits are reached, the defendant is not entitled to relief. With respect to the preservation issue, counsel correctly cited the one objection that he lodged during the trial. That objection came during the testimony of the defendant's girlfriend when she was asked a question about the prior sales at the defendant's house. He did indicate that he wanted to renew his pretrial objection at that point. My recollection of the record indicates that he did not, however, indicate that he was requesting a continuing objection to that evidence coming in through other witnesses or other testimony throughout the trial. So in other words, he lodged one objection during one witness's testimony. He did not ask for a continuing objection. He then did not object when the same testimony came in on 2 different days during the testimony of 2 different witnesses about the prior sales. Our position is that pursuant both to KSA 60404 and to the case law that has interpreted that and applied it on many occasions, especially since King, that simply is not enough to preserve that issue for review, at least with respect to those other witnesses. Perhaps he has an argument that the limited testimony that was objected to was preserved for review. He certainly doesn't have any legal basis to say that he is then entitled to, on appeal, challenge testimony that he never objected to. Now, with respect to the Grow operation, he never lodged a single objection.
Well, that he didn't object to at trial. He objected to it prior to trial, right?
He moved to suppress it.
Right.
I wouldn't call that an objection, but regardless of how we
He
label it.
objected to the introduction of that evidence against him, did he not?
I'll concede. I'll call it an objection and say that it doesn't matter because the contemporaneous objection rule requires an objection at trial.
Well, my understanding is that the grounds of the objection, if we're calling it that, pretrial were this is a Fourth Amendment violation and the evidence ought to be suppressed. Is that right?
I don't recall specifically how the written suppression motion read, what basis. I think that it was...
Well, just for argument's sake, if we're going to give sort of the most liberal construction possible to the objection that was lodged at trial and sort of incorporate into that everything that he argued pre-trial, it strikes me as important to know exactly what was argued pre-trial with regard to that marijuana evidence.
My recollection of the pre-trial hearing was that it was there was a discussion about along 6455 lines. And I know specifically because the state responded in part that the Grow operation itself, or the marijuana that was found in the basement on the day that the police searched the house, that was not 455 evidence because it was part of the crime itself. It was discovered in the house on the day of the crime. And so I think there was focus at the pretrial hearing on it as far as whether it was 455 evidence and whether it should be admissible for those purposes.
And at trial, the objection that was lodged, is my understanding, is that came entirely in the context of questions about the prior sales.
The price,
it had nothing to do with what the police found when they came into the home.
Absolutely. Absolutely, and that is why, again, it's our position that even if you could argue that the defendant did preserve a limited right to challenge the testimony about the priors that came in through his girlfriend, that none of the evidence that came in with respect to the Grow operation and to the marijuana found that day is properly before this court. Also, that the testimony that Detective Chisholm and that the victim's wife gave with respect to the prior sales is also not preserved for appellate review. And that does get into the harmlessness analysis that Your Honor's questioned counsel about. One aspect of our harmless error argument is that because the same testimony about the prior sales, or the same type of evidence about the prior sales came in through other witnesses, that the defendant simply cannot show that he was prejudiced by the fact that it came in through his girlfriend. So again, our primary position is that this issue has not been preserved. I'd also note that in his brief, while the defendant does categorize these generally as far as saying that what he's contesting is evidence of the prior sales and of the grow operation. In his brief, he does not analyze or even cite any specific testimony of any particular witness, which makes it even more difficult to argue or to say that this issue is properly preserved and properly briefed. He's just lumping these broad categories out there without any specific focus on any particular testimony. While we don't think that it's appropriate or necessary to reach the merits, our position with respect to the merits is that the defendant, contrary to what he states in his brief, he very clearly did dispute his participation in this drug transaction at trial. In fact, that was the primary focus of the defense. If you look at opening statements and closing statements, his attorney made very clear on multiple occasions that in the defendant's view, this was, quote, not his deal. He consistently argued that essentially Betts and Character were free agents that were acting on their own, that this was their deal, that the defendant had nothing to do with it, that these two gentlemen were adults, that just the fact that the defendant knew them and knew what they might be planning to do does not make him involved in the transaction. So given the fact that he was challenging very strongly his participation and involvement in this, that did very much put his knowledge and intent in play. And for that reason, both the prior sales that he conducted out of his home or on his property and the grow operation that he was...
Explain that. Explain how knowledge was, just because he said he didn't do it, did he deny knowing what the green leafy substance was?
I know he never did. I don't think he ever denied knowing that there was.
How did knowledge? How was it relevant as to whether he participated in this sale or not?
Well, I think if you're saying that, hey, I live here, these guys are doing a sale outside or inside my house, whichever it may be, but I had no involvement in it. I just happen to be the person that lives here. I think that when you're making that your primary defense, it very much becomes relevant that you not only knew about it, you clearly know about this type of activity because you have willingly participated in prior sales in the very location with this very person that you were engaging in this sale with. I think that...
But he didn't deny that he understood what was going down.
He denied that he was participating, though.
Well, I understand that, but how does knowledge come in? Whether he actively, because he did it before, that means he did it this time? That's propensity. You have to tie in the knowledge as a relevant fact to what you're trying to prove.
That his knowledge, meaning the fact that he knew that this sale was going on and that he was an active participant in it, and I think that...
Well, now knowing that it's happening, he admitted to that, but how does knowing about growing marijuana make it more probable than not that he participated in this sale?
Well, this is where we have to separate out. You're asking apparently about the grow operation as opposed to the prior sales.
Okay, how does the prior sales make it more probable than not that he participated in this sale other than propensity, which is not permitted?
Well, and this is where sometimes I think the 455 analysis gets a little difficult because the legal terms of art as far as knowledge and intent and identity sometimes don't match up to what I think a layperson or even an attorney would think when you simply hear the word knowledge or intent or any of the factors. And of course, those factors are not exclusive. So I guess in making my argument, perhaps my argument won't match up exactly with the words or the definition of knowledge and intent, and it will just comport more with common sense. And to me, it's difficult to understand how anybody could say that it's not material to a disputed fact when somebody is trying, and again, this doesn't have to conclusively prove it just has to be relevant and make it somewhat more probable than not, that somebody who is saying, all I knew is that this sale was going to go on. I had no involvement of it. I'm innocent as can be. These guys were acting on their own. I just happened to live there. It was my property, but these guys are adults. They're able to do what they want to do without my permission. Given that defense, I struggle to see how it could not be considered relevant to a disputed fact, whatever you want to label that factor, that in fact this person does and has in the past from this very location with these same people committed the same exact type of crime that he's being charged with in this particular case.
And in that, I guess I just didn't pick up, but so if you can help me identify, what is the disputed fact that you're focused on?
Again, it's what the district court found was knowledge and intent. And
Of what, though? I mean, what is the, I still go back to what, factually, what is the disputed fact that we're...
His intent to be an active participant, I guess, would be the way to phrase it, to be a participant in the crime rather than simply being an innocent bystander who had no involvement other than the fact that he happened to be friends with Betts and Carricker.
So are we looking at knowledge of how cells go down? And the rationale for saying stay outside, I don't want him inside?
Perhaps of how the sales take place, although I think, and this gets into what counsel characterizes as the key issue that he wanted to talk about today, and I think that focused largely on his contention that his involvement was essentially over because he told these guys that everything was supposed to take place outside the home, and that once these guys came inside the house, I'm out. I'm done. That's my aiding and abetting is over because I wanted this to be outdoors. And I think that, first of all, the facts, the state presented plenty of evidence to show that that's not, in fact, what happened. There's no indication that he did anything to try and keep these guys outside. In fact, he clearly knew that they might come inside because he preemptively hid himself in a closet with a shotgun for just the type of scenario that occurred in this. But to the broader issue that counsel's trying to raise, saying that you can somehow limit your participation in this, that you can be an active participant in setting up a drug cell, but then you can basically say, oh, but if it goes wrong, I'm out. If that's accepted, we might as well do away with felony murder. That way, a lookout driver, a getaway driver could say, well, all right, I was involved with participating in planning the bank robbery, but I told the guys don't shoot anybody if something goes wrong. So if they do, I'm done. All I tried to plan was the bank robbery, but I told them not to kill anybody.
Counsel, is what you're trying to say is there were lots of different kinds of knowledge and intent floating around in this case?
Clear.
So that knowledge isn't limited, the knowledge that could be an issue isn't limited to what marijuana looks like or is, and the intent isn't limited to what he intended to do prior to the time these gentlemen walked into his home.
That is accurate, and a better way of describing what I've tried. But yes, I think
I thought that's where you were headed, but we were taking a while to get there, so I was trying to help you out.
yeah, he clearly knows how these types of sales go down, and I think the very fact that everybody involved in this sale, I know all three of the sellers, and I think all of the buyers, or at least two or three of them, they all armed themselves. This particular defendant hid in the closet with his shotgun. I think that does show a very strong knowledge of these types of sales and the fact that things often do go wrong and that you can try and script them out as much as you want and try and pretend that I thought everything was going to happen outside. But that, yes, based on these prior sales and his activity in those and involvement, that he did know about this. And to take counsel's argument one step further, could he say, well, I told him to come inside the house, but I only told him to come in the living room, and once they came in the bedroom, then I'm out. Or, well, I told him they could come in the bedroom, but not in the bathroom. I mean, clearly, he's trying to limit his participation, and the expression that is used a lot in these trials, I think, is in for a penny, in for a pound, and that's what felony murder contemplates. Again, very clearly, this defendant himself showed his knowledge of how these things can go wrong by arming himself with a shotgun and hiding in the closet. He might not have known exactly how it was going to play out, but he clearly knew that there was a serious threat of something going astray.
Counselor, is the law that if a person is participating in an attempted possession of marijuana with intent to distribute, and that turns into an aggravated robbery, that your participation in the first crime precludes your defending yourself against the second crime? Is that where we are here?
Are you talking with respect to issue 3, the self-defense?
Right, yeah.
Our position with respect to that is that the defendant's only argument that he advances with respect to issue 3 is based entirely on a misreading of the statute. When you look at the way that 215226 is written, he is relying on the exception that is listed in subsection C1. And the defendant would have this court believe that subsection 1 applies also to A and B. When you read the way the statute is written, and even just looking at the format of how it is written, it is apparent that the exceptions in 1 and 2 only apply to C. So our position is that yes, for somebody who is attempting to commit or committing or escaping from the commission of a forcible felony, that subsection 1 defense or exception is not available. So regardless of the factual arguments that he tries to advance in this case, it simply is that he is relying on a statutory subsection that is non-existent. I did not find any case law in which this particular argument was addressed. I don't think that it's ever been made, and I think the reasonable explanation is simply because it's not a statute or a subsection that's in existence. And I did find it telling that in the defense brief, they did offset the language or the word unless in the statute in a way that is different from the way that it actually appears in the statute itself. That might have just been a coincidence, or it might have been an attempt to make the statute look somewhat different than what it actually appears. But when you do read that as the way it's actually written, it does appear clear to the state that subsection 1 is limited to section C, and because he was charged with a forcible felony, then yes, that would be unavailable to him.
Counsel, just so I'm clear, it sounds like your position is once you have become involved in setting up a drug deal, whatever happens afterwards is ultimately going to be your responsibility.
Yes, I think that's a fair characterization of the state's argument, is and in this case it's a drug deal. In other cases, as I indicated earlier, it might be an armed robbery of a convenience store or a bank or whatever the case may be, but I think that the felony murder statute is designed to apply in that manner, that once you're committing a crime or attempting to commit this type of an offense, that you are responsible when things go wrong, and that's why the felony murder statute is there. That's exactly why it was developed by the legislature. Nobody here, including the state, is suggesting that the defendant intended to kill his friend on that evening, and of course that's why we would have never been able, or we didn't pursue this as a premeditated first-degree murder and instead charged it as a felony murder. So yes, Your Honor, that is our position.
And what legal label can we place on that, besides the way I just described it in layman's terms?
Well, I think label, of course, the felony murder statute itself, I think is the legal authorization for that concept. I don't know that necessarily, I'm not sure if I'm answering your question or if I'm fully understanding it. I think that would be my best attempt to answer it, though, would simply be that the language of the felony murder statute itself is what codifies or gives the legal effect to that theory, that if you are participating in that type of a criminal venture, that you are responsible for the ultimate death, even if it was not intended.
We've said repeatedly that it relieves the state of having to show intent and premeditation.
Exactly.
And what I was looking for, do these consequences have to be in any way foreseeable?
Well, I guess, as Justice Beyer pointed out, I guess legally the theory is that just by the very nature of the underlying crime, that the legislature has decided that in a sense, they are foreseeable, that these crimes are so inherently dangerous that anybody participating in them is essentially on notice that you are responsible for the outcome of that, even if it's not precisely what you went in intending to do. And so, to that extent, they're foreseeable because the legislature has essentially deemed them so.
They've been declared to be foreseeable as a matter of law.
Exactly.
That's,
Yes. I see that I'm well past my time, and again, I would submit the remaining issues on the brief unless there are questions. And if there are none, we would respectfully ask that the defendant's convictions be affirmed.
any more questions? Thank you, counsel.
Thank you.
You reserve 3 minutes for rebuttal.
Thank you. I suppose the first thing that I need to address or revisit is the question of whether there was a pretrial argument based by defense counsel in this case regarding the drug, the grow room or the other paraphernalia that was found in the basement. Volume 10, page 55, defense counsel says that there's it could be page 54, 1 second. Yes, page 53 and page 54. Counsel talks about the marijuana was brought by Ronald Betts from Derby. Didn't have anything to do with the marijuana grown on the property, marijuana on the location. He discusses the grow room, the marijuana that was in the basement, as well as any paraphernalia or other things having absolutely nothing to do with the offense charged in this particular case on this particular date, and that it should be excluded based on its extreme prejudice to Mr. Betts. Mr. Betts, I'm sorry. I think in some ways the argument or Mr. Beltz's defense was somewhat mischaracterized in that he, back to the 455, he did not assert that he had no idea what these people were doing in his home. There was plenty of evidence outside of this. There was evidence for the state to rely on outside of the other, this 455 evidence of the marijuana in the basement, all these other prior sales, which were sort of vague accusations of, we did this at Mr. Beltz's house on 2 or 3 occasions. There was, Mr. Beltz in his interview stated, I put these people together. His girlfriend stated that, these things weren't contested. They weren't material, they weren't relevant, and they were simply propensity evidence in this case. I think I would just respectfully ask the court to grant Mr. Beltz a new trial and reverse his convictions, unless the court has any additional questions for me.
I have one question. Do you have any specific response to your opposing counsel's statements about the subsection on the self-defense instruction?
Yes, I think that what I've asked the court to do is to consider the statute and what the trial court should have done and what should be done legally in this situation is to consider the statute as a whole, look at what the legislature is saying. Each of those involves some application of force or an initial aggressor situation. That final unless can be viewed as a catch-all for any situation involving those. This case really involved the question of, was Mr. Beltz involved in the commission of that felony and when this death occurred? That's really the critical question.
Which felony?
He attempted to possess and distribute marijuana. The predicate felony for this case that transfers the intent makes him liable for Mr. Beltz.
Because at the time, really, it was an aggravated robbery.
Exactly, because he's gone into his closet and these individuals basically, there's even evidence that they had no any intent to actually buy these drugs. They were going there to rob these people. And so I think it was incumbent upon the district court to say, in this unique situation, the real question for the jury is this self-defense claim valid? Not whether, as a matter of, not you to stop at that first section and say, you've been charged with a forcible felony, therefore you're precluded from self-defense. It was a factual question based on the unique facts of this situation that should have gone to the jury.
Can felonies overlap by different actors? I mean, does the start of the aggravated robbery necessarily end the other felony in the cell?
I don't think it. I don't think it would necessarily we could say that per se, that's always going to be the case. Again, I think just in the under the felony murder doctrine, you end up with a lot of very factually complicated and unusual situations where you're trying to assign culpability to individuals for actions that precipitated or changed based on the nature of all the different actors' participation.
I think that's exactly the opposite, counsel. I think the felony murder statute is set up so that we don't have to do all of that nitpicking in an individual case.
Well, I think that can be true, but in situations such as I had a prior case where the victim ended up shooting himself, and felony murder can lead to some serious results. As the state said, well, Mr. Belts never intended to shoot his friend. Well, the state stood up here and said, we don't think he ever obviously didn't intend to shoot his friend, but yet he's been, that intent is transferred. It doesn't matter under the felony murder rule. But what I'm trying to say is that you end up with based on the nature of these circumstances where these people are showing up in this case, their intention is to go there and rob them. My client says that all he wanted to do was put these people together so they can go do their drug transaction. Once those two crimes sort of overlap, it's very difficult to parse out exactly what.
But the crime here was not sale of marijuana.
It was attempted
possession. And what was the overt
intent.
act towards the attempt? And
the overt act charged by the state in the complaint was to put these individuals together. And then the other subject,
so that wasn't, if he put those together and that had been completed, then why wasn't the argument that he wasn't in the commission of that? Because during the sale or attempted sale, or one side wanting to sell and one side wanted to rob, that had nothing to do with Mr. Belts. Was that ever argued that the crime was completed?
Right.
The attempted possession was completed?
I think that's what counsel was trying to get at, and what I've tried to argue today is that once that part is over, he tells these people, okay, I've put you together, I've been charged with putting you together, I've been charged with having you meet. Those are the overt acts. Now that's done. You people go outside. Now they come in and commit an aggravated robbery. I guess the best argument is that the crime for which my client was charged is over. It's completed.
But we do have language in 2152-26 that's in the attempting to commit, committing, or escaping.
Or
and
escaping.
There's felony, similar language in the felony murders. So
I think
that seems to encompass a broader scope than.
Yes, it does. I guess my response would be in this actual case, there was no indication that he was escaping. He's hiding. He's hiding in the closet. And I think his testimony or his statement to the officers was that I saw these people come in, I went to the closet, and at that point I don't think he's trying to escape. This was as I understand it, this was really fast. These guys came in and basically just started shooting.
But how could we possibly get there? Through your second issue? Because you didn't raise the sufficiency.
No, I didn't raise the sufficiency issue. Through the judgment of acquittal issue, I think that would be a means to get there. Unless the court has any additional questions, we just ask for a new trial. Thank the court for its time.
I see no more questions. Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement.